is not a case fit for to proceed with under Article 184.3, would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, it cannot be challenged in appeal, except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184.3 petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
file. My lord, ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. यहाँ पे objection आ जाते हैं registrar के कि ये meet नहीं करता.
I'll tell you what's been happening. Number of 184.3 petitions have come up where the office has put objections. Yes. Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है उन्होंने objection लगा दी, not does not come within a parameter.
chamber appeal में जाना पड़ता है.
They've come to me, some of the absolutely ridiculous kind of petitions. They're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184.3 does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? एक जज. उसके खिलाफ क्या अपील है? कुछ भी नहीं है. End of story. ठीक है. तो यहाँ तो बल्कि वो भी jurisdiction बढ़ गया है. वो आपने हमें वो assistant registrar के पास हमें दे दिए हैं. उसके पास होना चाहिए assistant registrar के पास, तो रहने दें उसके पास. वो बेशक बेहतर तयन कर लेगा. जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184.3 का. राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184.3 की पिटिशन डिसमिस कर दी तो 199 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं. जो भी चीज़, यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया. इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. So I don't know what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184.3 में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटिशन आती है, जब कोई पिटिशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेंज अपील. सो दैट इज वन राउट. द 184.3 का दूसरा है suo moto. Now this actually, this provision in fact cures the problems in the process on both counts. First, 184.3 की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee where the appeal lies.
It is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें ये कि अगर 3 मेंबर समझते हैं कि दिस इज अ केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और जस्टिस इनकार कर जाता कि तीनों से एग्री नहीं करता. He has all the power, more power than 3 judges sitting in the court. The Chief Justice alone, sitting in a chamber, can undo this.
And the suo moto particularly, उसमें तो और ज़्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184.3, they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or wherever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184.3, the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against
My lords
that
can
order.
suitably amend the rules
You
and
see,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all these years.
You were too polite to say that.
My lord, we have section 4.
I've read that. Actually.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी तो उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the Constitution. So aren't you adding to the Constitution or amending the Constitution without an amended
Mr.
amendment
Attorney
in the
General, entry
Constitution?
55 says that we'll confer, enhance your jurisdiction. तो उन्होंने एक और 84 की अपील बना दी है. तो
Well,
enhance नहीं होगी
185 की भी फिर एक और अपील बन सकती है.
बना दें.
बन सकती है.
बना सकते.
सेकंड अपील तो है, हमें वैसे भी बताया हुआ है हमने कि हम
Speaking
दे
for
सकते हैं.
myself, Learned Attorney General, Learned Attorney
Why
General,
not a third
speaking for
appeal?
myself.
Why not then a third appeal or a fourth
Bana
appeal
दें.
or a fifth appeal?
Learned,
कब आएगी तो उसको
Obviously,
देख लें.
it's the parliament. Parliament won't do absurd things, and
No,
of
it's
course,
not a question of, no, it's
you
not
know,
a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया ना.
नहीं, infinity नहीं है.
Parliament
Obviously, you know,
देखिए,
we're talking
principle
about the
की-
parliament here.
देखिए,
We're
Mr.
not
Attorney
talking
General,
about.
आप बात फिर आ जाती है कंजेक्चर और थ्योरी और ये और वो बात प्रिंसिपल की हो रही है, असूल समझने की है ना. एक दफा एक बात को कंसीड कर दिया जाए, एक्सेप्ट कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
Lord,
This is the
great
point.
respect. I would
देखिए ना, रिव्यू
disagree.
जुरिस्डिक्शन भी है ना. अब रिव्यू जुरिस्डिक्शन का क्या कॉन्सेप्ट है कि सुप्रीम कोर्ट में फाइनलिटी हो गई, अब आप मैक्सिमम में रिव्यू कर रहे हैं. वो हमने
You know, with great respect, when it comes
ये
to
देखो ना, ये जरा
even on this plane, even on this
आसान
plane,
बात
and
नहीं है.
even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can
even-
go to the next point?
Ji.
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184(3), which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And-
so I don't see how...
And in a context where this court becomes the first and the final court in the same proceedings.
You
Where-
done? Are you done?
My lord, to this extent, and I'm just going to conclude my other two submissions here. I have placed on with my
we'll
paper
certainly
book the
look at
judgments
it,
of
don't worry.
in Baz Mohammed Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my lord. My lord, section 6 now, right to.
There was one concern also expressed
What,
by
Mala?
Justice Aisha
जी, वो मैं
Malik,
address
which
करना
was that
Sorry.
if we follow this procedure, then when the full court meets, then the appeal goes away एक ये भी पॉइंट था, इसको आप कैसे एड्रेस करेंगे? बिकॉज आई मीन वन आंसर कुड बी कि इफ द विजडम ऑफ ऑल इज सच है, तो फिर वो नेचुरली सब लोगों ने सारे एंगल देखे होंगे, या आप कैसे एड्रेस करना चाहते हैं?
उसमें एक ये बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे,
इस हद तक रीड डाउन करें
जहाँ पे फुल कोर्ट होगी, नेचुरली अपील जो है वो लिटरेट हो जाएगा, बट आप उसको ये कर सकते हैं, सॉरी सर, just
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My lord, ये अब 15 बैठे हुए, so मैं जैसे just was saying, so if it was in original proceedings it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना, फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 member बेंच बन जाता है, फुल कोर्ट तो नहीं है।
My lords would be mindful of this.
अब ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब, फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं। आप देखिए ना, आप इसको एड्रेस कीजिए ना, ये ऐसी बात नहीं है कि द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया।
what I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर।
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना, नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना, व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी। व्हाट यू आर सेइंग इज दैट सब्सटैंटिव राइट दैट यू हैव क्रिएटेड अंडर द स्टैट्यूट is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं, तो फिर आपने ये right दी किस मकसद के लिए?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया।
So let me just
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई।
Actually जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी, तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं full court बनाई जाए, आपको तो कहना ही नहीं चाहिए कि full court बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMAs क्योंकि वो hearing पे नहीं गई,
but the burden at the end of the day was on us.
The question was in fact put by me, and so therefore it's not that the question was not there.
My lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8-member बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं, अगर हम बेंच पे एतराज़ कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 member बन सकते व्हाई नॉट फुल कोर्ट?
So मैं इसका brief एक response दूँ and then followed by a detailed response in writing. Briefly put, and that would perhaps address Ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती.
In cases, in circumstances में ये हो सकता है, जैसे अभी भी है.
Repercussions तो सोचिए आपकी बात की कि यही precisely सवाल है कि इस लॉ की इस सेक्शन की वजह से.
So let me put it differently.
Now फुल कोर्ट कभी बैठ ही नहीं सकती.
नहीं, फुल कोर्ट आप बैठेंगे
in exceptional matters, which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled. My Lord, Section 6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when a situation of this sort arises, that be so.
Right of appeal पे substantive right नहीं है, जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184.3. With great respect, And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
साहब, यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए.
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Applications of your submission तो kindly देखिए.
मैं उसको ये इस तरह से आपको कर देता हूँ कि आप
Attorney General साहब, let's be, we are all grown-ups, right?
Attorney General साहब,
can I just, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy, we don't understand the repercussion of things. Fine, I'm not saying that judges who decided that, they did what they thought at that time, how they were assisted, according to the conscience, correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review, unanimous, because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं, मान लें गलतियां हुई हैं. ठीक है, हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है. ठीक है, अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज मेड लॉ हम उसको रख लेंगे अपने ऊपर, तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा